Welcome to the new episode of Case Law Today.
In this episode, we are going to discuss about a most recent judgment of Tripura High Court. The bench held that petty quarrels arising out of discord and differences in conjugal life would not amount to cruelty. The bench, comprising of Justice Talapatra and Justice Chattopadhyay, observed that the parties belong to the poor strata of society.
It was, therefore, not unlikely that there would be discord and differences in their domestic life. Petty quarrels arising out of such discord and differences in conjugal life would not amount to cruelty, within the meaning of Clause A of Section 498A IPC, unless it is proved that the cruelty meted out to the wife was a willful conduct of the husband, or his close relatives, which was likely to affect her normal mental frame, and drive her to commit suicide out of depression, or to cause grave injury or danger to her life, limb, or her mental or physical health. For establishing the commission of offense under Clause B of Section 498A IPC, it has to be established that the husband or his relatives subjected the victim to harassment, with a view to coercing her or persons related to her to meet any unlawful demand for any property extra.
The judgment, authored by Justice Chattopadhyay, said that it goes without saying that matrimonial cruelty occurs within the precincts of the matrimonial home of the wife, and she hardly shares her ordeals with someone other than her parents and her near relatives. As a result, overwhelming evidence may not be available before the court in a case under Section 498A IPC. But that does not absolve the prosecution from the burden of proving the charge by cogent, coherent, and persuasive evidence. In the case in hand, the matter was reported to police by the father of the victim after he brought back his daughter from her matrimonial home. It is apparent on the face of the record that the victim lived with her husband in her matrimonial home only for about 6 months after their marriage. Except the omnibus statement of the victim and her parents that the husband demanded cash from the parents of the victim, and tortured her for fulfillment of his demand, no particular incident of any kind of physical or mental torture meted out to the victim, or any other instance of abuse in her matrimonial house has been proved against the husband. In Manju Ram Kalita vs. State of Assam, the apex court held is under cruelty, for the purpose of Section 498A IPC, is to be established in the context of Section 498A IPC, as it may be different from other statutory provisions. It is to be determined, inferred by considering the conduct of the man, weighing the gravity or seriousness of his acts, and to find out as to whether it is likely to drive the woman to commit suicide extra. It is to be established that the woman has been subjected to cruelty continuously, persistently, or at least in close proximity of time of loading the complaint. Petty quarrels cannot be termed as cruelty to attract the provisions of Section 498A IPC. Causing mental torture to the extent that it becomes unbearable may be treated as cruelty.
In the case of Pratash Datta vs. State, Tripura High Court held that every case of harassment of the wife either by the husband or his family members cannot be termed as cruelty within the meaning of Section 498A, unless the conduct of the husband or his family members, as the case may be, is willful and of such a grave nature, which is likely to drive the wife to commit suicide, or to cause grave injury or danger to her life, limb, or health, whether mental or physical.
Similarly, in Gautam Nama vs. State, Tripura High Court observed that, on the basis of mere omnibus statement without specific evidence regarding the particulars of the instances of such torture or cruelty, the accused cannot be held guilty under Section 498A IPC. In the case of Dhananjoy Sheel vs. State, also it was held by Tripura High Court that a single incident of assault may not amount to an offence under Section 498A IPC, because cruelty for the purpose of Section 498A is different from other statutory provisions, and it is to be established against the husband or his relatives that he subjected his wife to cruelty, continuously and persistently. It was also held that petty quarrels cannot be termed as cruelty, to attract the provisions of Section 498.
In view of the evidence and the law enunciated in the decision cited above, the bench viewed that the prosecution could not establish the charge of cruelty as enumerated under Section 498A IPC, and therefore, the conviction under Section 498A IPC is liable to be set aside. Subscribe this channel for more case law videos.